Hello, everyone, and welcome to this third episode of White Collar Coffee Conversations. As a group of forensic accountants who work with attorneys and investigators on cases related to financial fraud, complex commercial litigation, valuation, damages, and many other issues, we're putting together brief interviews with leaders across the financial and legal world to provide you with insights on our work and to look at the trends going forward. I'm Chris Ekemoff, a CPA with experience in fraud cases, Ponzi schemes, and white-collar litigation. On this episode of WC3, we're taking a look at the new enforcement posture at the Securities and Exchange Commission. To help us cut the regulatory wheat from the chaff, we're joined by Michael Liftik of Quinn Emanuel. Michael chairs the SEC enforcement practice at Quinn and is co-managing partner of the Washington, D.C. office. Prior to his time with Quinn Emanuel, Michael spent a decade as an attorney at the SEC, first as a line attorney in the Division of Enforcement, and then as senior enforcement advisor to then-chair Mary Jo White, and as deputy chief of staff to the agency. Who better to join us today to talk about the shifting sands at the SEC than Michael? Welcome to White Collar Coffee Conversations.
Thanks very much, Chris. Really glad to be here today.
All right, let's dive right in. As early as 1972, the SEC has utilized what's called a no-admit, no-deny policy on certain civil enforcement settlements, and not without criticism. However, newly appointed director of the Division of Enforcement, Gurbir Grewal, has recently spoken out about a de-emphasis in utilizing that policy and stating the SEC will require admissions in certain matters. Michael, what's at stake in this new posture regarding admissions?
Yeah, thanks, Chris. Well, first of all, I think it's important to point out that this isn't actually a new posture. Actually, my former boss, Chair Mary Jo White, rolled out an admissions policy for certain cases, and under her administration, the agency did obtain admissions in a few notable cases. However, as I was there, what we learned during the time, and what I think this administration will also learn, is that this is something that is much easier to say than to actually do. And the reason is the collateral consequences that come with an admissions. So it really doesn't have as much to do with the SEC's own admissions, but what happens to the defendant if they admit in other areas of the law. So to take a very prominent example, if there's a class action litigation and there's an accounting fraud case, if a company admits liability to the SEC, they've basically given up the ghost on the class action and would basically necessitate settling that case at extremely high dollars. For individuals, the stakes are even higher. All the federal securities laws are enforceable by the Department of Justice as criminal charges as well. So, for example, in an insider trading case, if a person were to admit liability in an SEC matter, they'd basically be handing themselves over in an orange jumpsuit and silver bracelets over to the Department of Justice. So I think what this administration will find is that while they may seek admissions, it's going to be very, very hard to get potential defendants to agree to admissions. Of course, the one exception to that is actually a longstanding policy that dates back to the Mary Shapiro era, in which if a defendant has already pled guilty in a criminal case, the SEC's no admit, no deny policy doesn't apply, and the SEC will insist on admissions in those cases.
I like your comment about silver bracelets. As we're recording this heading into the holiday season, let's hope that no one has those on their list for Santa to bring them. On a similar idea, Chair Gensler over the summer has made waves recently regarding his comments about individual accountability. Michael, how does individual accountability kind of differ or fall in the same vein as no admit, no deny? How has it been viewed in the past few decades, and how do you see that changing based on the posture that we've heard from the SEC this summer?
Yeah, again, Chris, I think there's, to some degree, nothing new under the sun here. An emphasis on individual accountability is something that you hear out of, I believe, every enforcement director over at least the last 5 or 6 enforcement directors that I can think of. And from a policy perspective, from the SEC's perspective, it's important if you're going to be trying to enforce the federal securities laws, if you're going to try to deter future violations. Yes, you can bring cases against companies, but companies are ultimately run by people, and so you need to show people that they will ultimately be accountable. So I understand where the instinct comes from, and there's lots of examples where the SEC successfully brings cases against individuals. But again, the challenge here can be in the actual doing. individuals obviously have more at stake sometimes than a company or an entity. And so they're more likely to fight. They're more likely to press the SEC to its burden. And so it comes down to resources for the SEC. Do they have the trial resources to bring cases against individuals when there's a settlement against the company in the offing, and you can get the message out there, they can get their penalties, the matter will be concluded, versus litigating in federal court for the next several years, where they really have to assess the sufficiency of their evidence and whether it's worth the resources or not. What we have seen with this administration is an increased focus on individuals, at least in the investigative stage. I think the numbers will take some time to see if that bears out at all. But at least in some of my matters, we are seeing a more aggressive pursuit of individuals. And on this point, I think it's simply worth reminding the agency, if anyone out there is listening, that just because you can bring a case against individuals doesn't necessarily mean you should. It's a very serious thing to charge an individual. It has career implications. It implicates their entire life's work often. And so the agency really needs to look hard at, just because potentially some, for example, regulatory footfalls might exist against an individual, do those potential violations warrant destroying someone's career, kicking someone out of the industry, et cetera? It's a very serious thing that really needs to be calibrated appropriately and fairly.
Well, Michael, it's no secret that you work day in and day out with your clients that are facing regulatory scrutiny, as well as other clients who are preparing themselves to be compliant with this kind of shifting landscape of rules and policies from the Commission. What key areas are you and your clients focusing on today in response to this new SEC enforcement administration?
That's a great question, Chris. I think it would come as no surprise to anyone listening to this that there is a heavy focus on cryptocurrency and digital assets. It is something that Chair Gensler has put squarely in the crosshairs and has been in the crosshairs for some time. There's definitely some days where I wake up and I feel like it's all crypto all the time. But the other areas are ESG, environmental, social, and governance. The SEC has rolled out an enforcement task force on that area. I don't think we've actually seen any cases yet, but certainly on the client side, we are working with clients to remind them that that wave is coming. And so both on the public issuer side and on the fund side, clients need to be thinking about their disclosures, their investment mandates, and thinking ahead to future enforcement sweeps and what that might look like. And then, of course, you're going to have the usual bread and butter SEC cases. I think we've seen an uptake in insider trading cases recently. Financial and accounting fraud cases seem to be on the move again. And, in particular, on the private fund side of things, hedge funds, private equity funds, we're working with our clients in tightening up their compliance, doing appropriate reviews, as it seems like this administration is going to be taking a closer look at those types of entities as well.
Excellent, Michael. Well, I know you and I could talk for hours more on SEC enforcement issues, but we're so grateful to have you join us for this episode of White Collar Coffee Conversations. Thank you.
Thanks, Chris. This was a lot of fun and love to keep the conversation going.
We want to thank our viewers and listeners out there for your interest in this podcast and video series. If you've got a topic you'd like us to discuss in the future, please reach out to me on Twitter or LinkedIn to get connected. Thank you, everyone. And until next time, here's to good coffee and good conversation.